Good afternoon, ladies and gentlemen, and thank you for joining us. As you are aware, every Thursday between 4 p.m. and 5 p.m., the South African Bar Association hosts a speaker to deal with a legal topic intended to assist young practitioners with training and development, which feeds into the core values that we hold as an organization. It brings me great pleasure in introducing today's speaker, which is no stranger to us, Judge Graham Moshoana. Judge Graham Moshoana shall be addressing us on a topic titled, What is the level of professional conduct that judges expect from advocates and attorneys when appearing in court, virtually or in open court? We are honored to have Laura Mbeletti to conduct the welcoming and conclusion of Judge Moshoana. In terms of housekeeping, these sessions are recorded and appeal to participants to ensure that your microphones are muted and that your video cameras are switched off. In that regard, during the address, all participants shall automatically be muted. Should a participant have a question, simply raise your hand using the Microsoft Teams platform. Alternatively, pose such question within the chat box, and that question shall be put to Judge Moshoana. During the question and answer session, a humble request is made to restrict questions to the speaker relative to the topic under discussion and only pose such questions when called upon. I now hand it over to Laura to conduct the welcoming of Judge Moshoana. Over to you, Laura.
Thank you, Ahmed. Judge Graham Moshoana is currently a judge at the Labour Court. He took the bench in June 2007. Prior to that, Judge Moshoana acted as a judge in the Labour Court for a period of 10 years. This was during his 22-year tenure at Molava and Moshoana Incorporated, where he practiced as an attorney after commencing his legal career as a candidate attorney at Museneke and Partnerships. Highly scholastic, Judge Moshoana holds a BProc, LLB, LLM, and higher diplomas in corporate law as well as labor law, and is currently pursuing his LLD in mercantile law. It is a great honor and privilege to have Judge Graham Moshoana as an esteemed guest today, as he'll be giving us insight on court decorum. Without further ado, I hand it over to Judge Moshoana to give us a presentation on today's topic. Over to you, Judge Moshoana.
Thank you very much. Thank you, Laura, and thank you, Ahmed, for inviting me. I think today's topic is largely going to concentrate on the conduct and less about the law, although at times there will be reference to the law, but the topic today or the talk today, I understand it to be more related to the professional conduct that is expected by judges when practitioners appear in courts. And in this instance, I would be more focused on the labor court as the division that I sit in. Perhaps as a form of introduction, what prompts this topic is the experience judges are exposed to of late, particularly in the labor court. That experience calls for the back to basics talk like this. South African courts in general play a critical role in the present constitutional order. In terms of section 165(2) of the Constitution, courts are seen or are supposed to be independent and subject only to the Constitution and the law. Now, interestingly, the literal definition of a court is a body of people presided over by a judge. Therefore, legal representatives form an integral part of a court. It is for that reason that legal practitioners are oftentimes referred to as officers of the court. But in general, they form part of the court. They constitute the court, and the court is presided over by a judge. Now, effectively, when the Constitution says that the courts, or prescribes that courts are independent and subject to only the law and the Constitution, that, in my mind, includes the legal representative. Because you can never be a legal representative, or let me put it this way, you will never have any audience as a legal representative except in a court of law. Now, the experience that I am referring to is that lately legal representatives seem to adopt an attitude of us and them. Us being the legal representatives and them being the judges or the presiding officer in general terms. Now, that attitude, of course, it is not one that should be welcomed. Because once a court is constituted, presided over by a judge, there is no longer us and them particularly between the court, the judge, and the legal representative. To a point that I can boldly say that that attitude of us and them is effectively unconstitutional in my mind. Let us remind ourselves of the duties of legal representatives when they appear in court. Obviously, based on their experience by the judges, the us and them kind of attitude continues unabated. There is a strong belief which has to be rooted out with immediate adequacy that judges or presiding officers are not in the same pool as legal representatives when it comes to a court setup. Again, I emphasize that prompted this talk. In fact, it is more discussing ethics, but a little bit more in terms of what the judges themselves particularly expect at the level of professionalism. There are a number of duties that we probably all know apply to legal practitioners. First and foremost, you have a duty as a legal representative to keep dignity and self-respect. In as much as legal representatives owe a duty to their clients, they have to do so with dignity and self-respect. As I indicated, that I will focus largely at the labor court. In the recent past, the Labour Court issued a contempt order against an advocate. Of course, the immediate question that may arise is this not a disgrace to the profession? Of course it is. It is not expected of officers of court to find themselves faced with contempt orders without really getting into the details of the facts of that case. It's, as far as I can recall, it's a reported judgment. But of importance is that if we now get into a point where judges would then make contempt orders against practitioners, this must be worrying. Something needs to be done, particularly by the profession itself. The second duty that I want to refer to is the one of keeping in mind the dignity of the judge. As I indicated earlier, a judge who, in general terms, a presiding officer, presides over the court. I indicated earlier that legal representatives also form part of the court. But there is a person in charge of that court, and that person is the presiding officer. He or she must be accorded the dignity that is commensurate with the role. The judges are supposed to keep the decorum that is required in the court. Again, the experience is that some legal practitioners do not keep this dignity issue in mind when they appear in court. Ordinarily, judges, and probably those that have appeared before me, would share the experience that judges are supposed to be debating the law with legal practitioners. And in as much as it can be said that judges do err when they finally determine the matter, but at the time of appearance in court, when you are being given an audience by the presiding judge, it is in order to maintain that dignity of the judge. Some legal representatives walk alongside that principle of keeping the dignity of the judge and want to show off, as it were, how much of the law they know more than the judge himself or herself. That is unacceptable. Legal practitioners in court make submissions. They are not there to argue with the judge or the presiding officer. They make submissions in order to persuade the judge to find in favor of their respective clients. Now, recently, or at least the trend, is where a judge debates the law with a legal practitioner, And for some reason, the legal practitioner takes a view that this particular judge has just been appointed to the bench or is an acting judge who has just recently started acting, would not understand the law as I do, because perhaps I've been practicing for many years. They make this kind of a statement, which I certainly, and I emphasize, certainly do not see it as a submission. I disagree with you, my lord, or my lady. It is not the role of a legal practitioner to disagree with the court. Where a court or a judge subsequently errs, there is a process in place, very dignified process, wherein the views of the judge may be overturned by a higher judge, by a higher court. But it is completely unacceptable to, during the submission, issue or utter statements like, I disagree with you, my lord. And in some instances, it is accompanied by with respect. Even if it is accompanied by with respect, it no longer constitutes a submission, but it is some form of challenging or even impacting on the dignity of the judge. You're not keeping that in mind as a legal practitioner. And as I said, once the judge errs in a judgment, you are more than entitled to challenge, appropriately so, the judgment through the higher court. So in my view, this statement of openly in a court saying to a judge or a presiding officer, I disagree with the court, it is something that is very much condescending in my view. And I'm not suggesting that judges are not wrong. They are wrong in law in many respects, and they have been overturned. I've been overturned myself. But once I am in a court, the decorum that is expected and the dignity that ought to be kept is that I am in charge, not in an oppressive manner, but in the manner that will make sure that a court as an institution would garner the respect that it ought to be given by members of the public. So this duty of keeping in mind the dignity of the judge, doesn't matter whether a judge is an acting judge, doesn't matter whether the judge is a woman, as probably in some instances and some stories one had, is there is some level of attacking the dignity of the the colleagues, lady colleagues. So it really doesn't matter. In order to keep this dignity flowing, you must keep that at the back of your mind whenever you address the court, and whenever, as I emphasize, making submissions. You're there to make submissions. The third duty, you are not entitled as a legal practitioner to remonstrate against the judge. There are instances where, when a court, for instance, make some interlocutory rulings in the process of the matter, you see counsel that, or the legal representative that appears for a party that has lost on that particular point, pulling faces, shaking heads. Of course, the suggestion is that the judge does not know what he or she is talking about. Clearly, this is also linked to the issue of the dignity of the judge. That pulling of faces and shaking of head behavior is unacceptable. I do not believe that it is in the interest of your clients to show a disrespect to the bench, because at the end of the day, the fate of your client's case is in the hands of the judge. Now, now with instances where we do matters virtually, there are incidents where, of course, maybe technology somehow assists us as judges to hear certain things that we're not supposed to hear. But you take a break, and for some reason that there might not be a disconnection, and you'll hear a remonstration at the background. Now, clearly, and I know in the situation where if this was happening in the open court, you might have that talk in the corridors and have issues with the judge. But with the virtual hearing, you will hear certain things that you're not supposed to hear. But at the same time, legal representatives are entitled to complain against a judge through a process and proper channel. Now, you will not expect remonstration that often happen in court. That goes back to, for lack of better word, insulting the institution that is court as defined in the Constitution. The other duty, this goes to, it may appear to be insignificant, but it is important. The dress code. Much as we would appreciate your pink shirt at a wedding, but certain dress code is inappropriate. And it always baffles me, why would we still have this kind of issues when the practice manual of many courts is, and the labor court in particular, do state the type of dress that is required, even on virtual. Now, if that is kept, it is a level of professionalism, it is a level of keeping the dignity of the institution called the court. The other duty is the duty to cooperate. It is expected from the legal practitioners to assist the presiding judge. It is it is not, and I'm going back to the us and them, it is not a situation where you feel that it is appropriate for me, for you as counsel to pull faces and somewhat remonstrate against the judge, clearly showing that I am not cooperating with you, irrespective of the fact that you are in charge of this court process. The duty to cooperate in the labor court extends to a situation where legal practitioners, they are appearing against unrepresented litigants. When you know of some authorities that are against you on a particular point that you are making, and you know for a fact that the poor lay litigant would not know about those authorities, it then becomes your duty to bring that to the attention of the judge. That these two cases, or three cases, or whatever number, are with me on this point of the law. But these two or three or even more cases are also against me. So that then the court must adjudicate in a fair and appropriate manner of whatever dispute. But taking advantage of the lay litigant and not bring those authorities to the attention of the court, it might lead to a decision by the court that does not take into account those authorities when you, as the legal practitioner, knew or know about those authorities. So that also is unacceptable. You have a duty to act honorably with dignity and integrity. Again, I go back to the very judgment that I spoke about earlier, where this court, the labor court, has issued a contempt order against a advocate. Now, clearly, that is an act which is dishonorable, which indicates lack of dignity and integrity. Now, a further duty, and we see this a lot in the labor code, double briefing. I know that it is against the rules of the Bar Council or even the legal profession to be double briefed. But we see this quite a lot, where the labor court, for instance, would keep a continuous roll for a trial, and counsel or an attorney would accept a brief to represent a party in that trial. Even if the pre-trial minute says it's going to be a 5-day trial, on the third day, you then get to hear things like, my learned colleague has indicated to me that he's got difficulties on Thursday or Friday because he is unavailable. Of course, at times, this is hidden from the court why the unavailability. But it turns out that it is because of double briefing. That is unprofessional. The other unprofessional conduct is where, and again, I will emphasize in the labor court, you find that it is a huge matter. It involves a number of respondents or a number of parties, and a number of counsel do appear in court. What I have observed is where counsel makes his own submissions with regard to the part of his or her case, and thereafter leave the proceedings. without the matter having been concluded. Again, that's unprofessional. In the course of hearing the matter, I may remember as a judge that Mr. So-and-so made the point when he was making submissions. And I would want to get confirmation from Mr. So-and-so. Mr. So-and-so has left the court proceedings without being excused by the judge. That is unprofessional. What we also see in the labor courts is what I would term judge shopping. Allocation of matters to judges in any division is the responsibility of the judge president of that division or the senior judge. Now, there appears to be a growing tendency of practitioners shopping for a particular judge. For instance, if Judge X is allocated a matter or to conduct urgent court, legal practitioners tend to agree amongst themselves to postpone an urgent application simply because they do not want to make an appearance before Moshoana and hope that in the next occasion they will draw a favorable judge. Again, that is unacceptable and unprofessional conduct. The question that I always ask when I'm faced with this situation of wanting to postpone an urgent matter, I ask the question, how do you postpone an urgent? And in most instances, you find that it's counsel appearing for the applicant that is bringing the urgent application and say, by agreement between me and my colleague, the matter is going to, we want the matter to be postponed. The practice manual of the labor court says that if parties require to file certain papers, an arrangement can be made to stand the matter down to enable the parties to file those papers. But more often than not, you just see counsel standing up and wanting a postponement of an urgent. And I just get gobsmacked and say, but what is this? Now, that is something that needs to stop and end. And this is related to counsel accepting instructions. You don't accept an instruction to postpone. How do you accept an instruction only to postpone? I've seen instances where counsel stand up when the matter is here, even in the urgent court. My lord, my instructions are to postpone. Now, what if the court doesn't grant you postponement? What happens? Then the matter doesn't continue. More often than not, those counsel would withdraw and say that my instructions were to postpone. How on earth do you accept an instruction to postpone? You shouldn't accept an instruction to postpone. Either you are available or you are unavailable, or you are ready to assist the court with the matter, or you're not. Heads of argument. The labor court deals a lot with review proceedings out of the bargaining council or the CCMA. The tendency that is existing is to lump the court or the judge with a 40-page head of argument where you quoting Sidumo, Harold, Mufokeng, and all other judgments, but without really giving the judge the background facts, the relevant portion in the record that you want to rely on. All of that, it's not helpful to the court, and the practitioners must stop that. Even if you file 2-page heads of argument, but addressing a particular point, that becomes helpful for the court. I'm not suggesting that you should not cite authorities in support of whatever proposition you're going to make, but you don't give me a chapter and a verse of the entire Sidumo, or entire Herald, or entire Mofuke. So that in itself, it's a conduct that is unacceptable. Now, on the Zoom, and there's a when you conduct matters on Zoom, there appears to be a tendency of just somewhat getting used to each other as if it is not in a court of law. Judges will receive emails directly from practitioners simply because the email of the judge has been shared for the purposes of the link. That is unprofessional. That is unacceptable. As I conclude, judges appeal to practitioners to act professionally so that justice must be delivered swiftly to the South African public. Certain mannerisms by practitioners do not assist in the delivery of justice to the public. I'm hoping, organizers, that this talk will knock some sense so that we can return to the era where judges are accorded the dignity and respect they deserve. Thank you very much.
Judge Moshoana, on behalf of the South African Bar Association, the participants, and those that will be watching your address at their leisure, I thank you for providing us with such an informative address. I have now opened a platform for a brief question and answer session. By way of a reminder, to those participants that have a question, simply raise your hand using the Microsoft Teams platform, and when your name is called, simply allow your mic and or your video to pose your question directly to Judge. Alternatively, type your question within the chat box and such question shall be put to Judge Moshoana. Judge, there's a question from Bart Ford. Bart Ford, you can simply allow your mic and or your video to pose your question.
Good afternoon, Judge. Thank you so much for that informative presentation.
Yes, thank you, thank you. Afternoon,
Judge,
Mr. Ford.
I've got 2 questions.
Yes.
One is, whilst we accept that there is a responsibility, and where I am, it's storming, so I hope Judge can hear me.
Yes, I can hear you.
Whilst there is a responsibility on the part of counsel and attorneys to always interact with the bench respectfully,
there will be.
Surely.
No, but no, Mr. Mkari, where is that case law? I have seen a constitutional case law that concerns matters obviously of issues that are enshrined in the Constitution. I have seen that because a person is supposed to be allowed an opportunity to exercise their threatened right. But in
I don't know what's happening.
Are you saying? Can you hear me?
Yeah, now I can hear you.
Yes, I'm saying I've seen a constitutional.
Sorry, back to you, Bart. Sorry about that.
Yes.
Apologies for that, Judge.
Yes.
My question, the first question was, whilst we accept that there is a duty on the part of counsel and attorneys who appear before the court to always treat and interact with the court respectfully, surely there's a reciprocal duty on the part of the bench to also treat counsel respectfully. I can cite without too much trouble difficulties that I've personally experienced in court where a judge would, for instance, say, whilst you're arguing a matter, is there anything else? Is there anything else? Is there anything else? Or impatiently pat on the bench or click the pen. And it gives you the impression that the judge had already made up his or her mind on a matter. And it doesn't augur well for the requirement to have this reciprocity in respect that there ought to be between the bench and the bar. That's my first question. The second question I have, often insofar as when it comes to contempt orders, I specifically know about an instance where a contempt order was granted against a counsel because his cell phone was ringing in court. And I submit, surely one should obviously assess the circumstances of situations before giving such an extreme, if not a draconian order of contempt where, and all of us make that mistake where you think your cell phone is on silent, but in fact you've left it still on. So if Judge could possibly address those two questions for me. Thank you, Judge.
Okay. Thank you very much, Mr. Ford. Of course, you are absolutely right that there is a reciprocal duty to treat counsel also with respect. In fact, to the extent, as I have said, that if you as counsel believe and feel that you've not been treated appropriately by a judge, there is a process that ought to be followed. It doesn't call for remonstration simply because you believe that you've been treated in a manner that is unacceptable or with disrespect. Now, when judges, for instance, you made an example that a judge would ask, as you say, impatiently, do you have any further points to make, or are you done, or anything of that sort? At the back of the mind of the practitioners, they must know, particularly in a motion proceeding, judges come to court having read your heads of argument, having prepared on the matter, and having identified the issues that needs to be addressed. Now, in a situation where a judge is pointing out whether you are done or anything of that sort, it could be for reasons that you are already not addressing the real issue. The judge has a huge role for that day. And as I say, effectively, I'm not suggesting that you should be treated with disrespect. But at the back of your mind, as a practitioner, you would know that you have made your submissions by written heads. And more often than not, we have read that. And if a judge is with you on that point of the law, you don't need to hammer it any further. So, but the short answer to all of this is that if you feel disrespected, the process is to deal with the conduct of the judge in a manner that is prescribed. The contempt cell phone, or cell phone contempt, if I may call it, of course, it is contemptuous to have a cell phone ring in court. Yes, it may be accidental, but many other things may be accidental. But the expectation is that counsel, before getting into the courtroom, you would have to check and establish that your phone is off, because you know that there's a possibility of that phone ringing whilst you're addressing the court. Now, that in itself is contemptuous. Yes, it may sound and may appear to be draconian in ordering contempt against the counsel for that. But the question is, counsel should have known from the beginning that you can't bring a cell phone in court. And in my court, for instance, my associate would, even before I come in, ask the parties to switch off their cell phones and all. That serves as a reminder. But again, the dignity of the court is important. I suppose that with maybe the limited time it's afforded, I've attempted to answer your questions.
Thank you, Judge.
Yeah.
Thank you, Judge. Sorry,
Yeah.
housekeeping. I appeal to participants to ensure that your microphones are muted and that your video cameras are switched off. Judge Moshoana, I have a question. As expected with developments in practice, there are opportunities and potential challenges with an electronic judicial system and processes. Technology always presents unique challenges as potential technical errors, connectivity issues, as well as lack of knowledge of individual practitioners as to how to utilize certain digital platforms. Are you experiencing such technological challenges? And if so, how are you dealing with such?
Thank you very much, Mr. Jassat. In fact, we do experience those technical glitches, and to a point that judges have been resisting this, particularly conducting a trial virtually, because there are all sorts of difficulties and the trial doesn't run smoothly and all of that. But for instance, the labor court, for instance, I was informed by the judge president this afternoon that a decision is taken that we're going back to normal court because of those technical glitches that we experienced. It has caused so much of a backlog, that process of doing virtual proceedings. But unfortunately, it's a situation that was imposed on us in a sense. But yes, the short answer to your question, we do experience that.
Thank you so much, Judge. Judge, moving forward to the questions in the chat box, there's a question from Andrew Goldberg. I'm going to read it verbatim.
Yes.
As to how a notice of deemed withdrawal of review applications to be handed by the court. Presently, we as attorneys are giving them to the registrar and they are seemingly going nowhere. That's a question, Judge.
Yeah, I had lost you for a moment. You said the issue is about the notice of deemed withdrawal that are lost in the registrar's office.
Okay, Judge, with your indulgence, may I repeat the question?
Please
Thanks.
do.
From Andrew Goldberg. It states verbatim, please advise as to how are notices of deemed withdrawal of review applications to be handed by the court. Presently, we as attorneys are giving them to the registrar and they are seemingly going nowhere.
Oh, okay. No, I understand. Look, somewhat this question is a little bit outside what we're supposed to be debating or discussing today. But what I can say is that the issue of the deemed withdrawal is dealt with in the practice manual of the labor code. And the view I take, and I've taken that view in a number of judgments, that deemed withdrawal happens automatically. You don't need to file any notice to that effect. But to the extent that there is a notice that is served or filed with the registrar, those sometimes would not come to the attention of the judge, but if it does, then the judge will give a directive. So my view is that those issues should be dealt with by reading properly what the practice manual says with regard to deemed withdrawal.
Thank you so much, Judge. Judge, there's the last question
Yes.
is from Nanandi. I'm going to read it verbatim. Please may I inquire as to the view of judges who allow advocates to frustrate the process in every possible way while the other party is being emotionally or financially broken down, if not both. And then this is the goal of the party taking this. Judges do not often appear to take cognizance of this and the impact on the other party. Often it is the large corporates and their team against an employee and their budget team. I ask as to the view of the court, not rather ensuring justice rather than technical delays are the focus.
Thank you very much for the question. Again, I think that question effectively highlights the reason for this talk. It is when parties appear before a judge and litigants are both represented by counsel or an attorney, they have legal representation, both of them. Now, it is not the duty of the court to really appear to be protecting the one side. But if certain aspects are brought to the attention of the judge, for instance, if the attorney believes or counsel believes that the other sides are not dealing with the issues and it's simply delaying the matter, bring that to the attention of the judge and the judge will make a ruling. Now, it is not for a court to keep on saying to counsel, no, you can't say that, no, you can't do that, when the other party is also legally. So the expectation, and I think arising out of this talk, is that legal practitioners should know what they are supposed to do in court and should do what they are supposed to do in court for the benefit of their clients. Yes, Mr. Jassat.
Judge Moshoana, due to time restrictions, I have regrettably closed the question and answer session. We sincerely thank Judge Moshoana for his address and time. We further thank Laura for her welcome. The South African Bar Association is indebted to you. These sessions are recorded, and the recordings can be found upon the South African Bar Association website, that being www.rsabar.net. By way of conclusion, this is the last afternoon program that we shall be holding for the year 2021. Our next afternoon program shall commence during the third week of January 2022. Appreciation to all those that have participated virtually and that have watched the past afternoon programs at their leisure. And we hope that our goal in providing professional training and development to all was indeed achieved. We wish you a safe and fulfilling festive season and looking forward to continuing our initiatives during the new year. And thank you. Thank you, Judge.
Thank you very much. Thank you.